afternoon, and welcome to the annual Rush McKnight Endowed Lecture on Labor and Employment Law. I'm sure that some of you will remember that because of a speech condition I use speech-assistive technology. Through the generosity of Rush McKnight, a longtime leader in the field of labor and employment law, we have been able to offer lectures by academic and practicing leaders in the field of labor and employment law to the great benefit of students, faculty, and members of the university and wider community. We build on that tradition with today's lecturer, who for many years has been at the very top of the field of labor law in the United States. She served as a member of the National Labor Relations Board for 14 years, after being appointed by President Clinton in 1997, the third longest-serving member of the board in its 78-year history. She served in Democratic and Republican administrations, having been reappointed twice by President George W. Bush. She was designated as chairman of the NLRB in 2009. On President Obama's first day in office, and remained in that position until her term expired in August 2011. A distinguished alumna of Barnard College and George Washington University Law School. Her experience in labor relation high-level appointments at the Federal Mediation and Conciliation Service, including Deputy Director, and before that as legal counsel for the Bricklayers and Teamsters. So you might say she's been in the trenches as well as at a seat of power. I should also mention that her professional activity has included membership on the board of directors of the Economic Policy Institute, as a fellow of the College of Labor and Employment Lawyers, on the executive board of the Industrial Relations Research Association, and the American Law Institute. These days she has been educating students as a professor at the College of Law and School of Labor and Employment Relations at the University of Illinois at Urbana-Champaign, and at her alma mater, George Washington University Law School. I'm sure that you will agree that it is our good fortune to have, and please join me in welcoming, Wilma B. Liebman.
I thank you very much to Professor Sharp for the invitation to be here this evening and for the privilege of giving the Rush McKnight lecture this evening. And thanks to all of you for coming this evening to talk a little bit about labor law during a very partisan time. Even for an institution created out of enormous crisis and struggle in the middle of the Great Depression, it is nonetheless been unprecedented what the National Labor Relations Board has been through over the last few years. And it is really, I think, impossible to have a candid discussion about labor law, labor policy, workers' rights in this era, divorced from the political storms of the last few years. And so that is my proposed topic for this evening. Before I outline for you what these battles have been over the last few years, let me start with what I call two facts, two factoids, and two questions. So, the two facts. There has not been a fully confirmed, Senate-confirmed 5-member NLRB since August 2003. That's nearly 10 years. There are supposed to be 5 members of the board at any one time, all confirmed by the Senate, nominated by the President with the advice and consent of the Senate. By tradition, those would be 3 members of the President's party and 2 members of the opposition. But since August 2003, there has not been a period with 5 confirmed members. So that's fact number 1. Fact number 2, there has not been significant labor law reform since 1947. And as one scholar, James Brudney, has said in an interesting piece entitled Gathering Moss, the resistance of this statute to legislative change, he said there hasn't been significant change to this law since Jackie Robinson integrated Major League Baseball, since TV entered American homes, and since the interstate highway system was built. So that gives you a little bit of a picture of the era of the statute that we are dealing with. So those are the two facts. The two factoids. During my nearly 14 years as a member of the NLRB, and I was the 3rd longest serving, I served in every configuration possible. 5-member boards, 4-member boards, 3-member boards, 2-member boards, and even 6 weeks by myself. The second factoid is that the longest serving member of the NLRB was John Fanning. He was a Democrat, first appointed by President Eisenhower and reappointed by 5 or 6 presidents after that. So he was on the board for, I think, 25, 26 years. During that time, he served with 14 different individuals. So I served for almost 14 years, but with 16 different individuals. So that should immediately tell you a little something about the political volatility of the period that I served on the board. Now my two questions. The first is, why is the NLRB and this statute a lightning rod today, some 78 years after the board was created, the statute was enacted, notwithstanding what most people would say is significant decline in labor law, what some call ossification, and notwithstanding the significant decline of the labor movement itself. So why is this kind of sleepy backwater agency long in the margins of political discourse? Why has it suddenly become a lightning rod today and in the center of political controversy? So that's question number 1, which I am going to attempt to address. I can't say that I have a fully satisfactory answer, but I'm going to attempt to address it. The second question is, and this question really has been highlighted by the most recent events, a decision of the D.C. Circuit Court of Appeals in January dealing with the constitutionality of 3 recess appointments that President Obama made to the NLRB in January 2012. My second question is the NLRB, which is really a quintessential New Deal agency, is it still politically viable as an institution of governance? Given what we see as a continuing crisis of governance, with a war against the New Deal ongoing, a lack of acceptance of the New Deal administrative state, with the use of the filibuster and other obstacles to governance and to the president's ability to make policy. Not to mention the continuing divide over the legitimacy of the labor law itself. So this question I probably won't be able to answer with any certainty. Is it still politically viable? But I think it is really a critical question that arises from what I am going to talk about. So, as I said, this statute and this agency are no stranger to controversy. They were created out of a period of economic crisis during the middle of the Great Depression, and the law was controversial from the very start. Nonetheless, what we've seen over the last few years, I think, represents an exceptional record of difficulties and an accelerating record of political difficulties. Notwithstanding, as I said, the fact that many people, many scholars in particular, have looked at the statute over the last 20, 40 years and used words like ossification, death, dying, and certainly decline. On the 75th anniversary of the enactment of the Wagner Act, Harvard economics professor Richard Freeman wrote, "It is perhaps harsh and impolitic at the NLRA's 75th birthday to declare that in 2010, the law no longer fits American economic reality and has become an anachronism irrelevant for most workers and firms." But that is the case. So the period that we've been through over the last few years of political difficulties is, as I said, not unprecedented. Once again, we seem to be in the middle of political turmoil. And in 1964, American historian Richard Hofstadter wrote a well-known essay entitled "The Paranoid Style in American Politics." And he wrote, "American politics has often been an arena for angry minds." Well, it would appear that once again we are living in this arena for angry minds, and there probably is no better illustration of it than the crisis over labor law, labor policy, workers' rights of the last few years. But more broadly in our political culture, it appears that our political discourse has been degraded. Epithets have replaced argument, opponents are vilified, and a sense of common values certainly seems to be lacking. Social conflict is not something to be mediated or compromised. Rather, there seems to be only a will to fight things out to a finish or total elimination of the enemy. As President Abraham Lincoln said in the early days of the Civil War, what is sought appears to be rule or ruin. If you can't rule, then ruin. So, from the start, this agency was criticized as being a tool of organized labor. It was attacked as being partial to unions and biased against business. An early commentator, writing in 1939 about the early controversy about the board, described the practice of anti-unionism in this country as deeply rooted in American industrial society. And with respect to critics of the board itself, he said that any inclination to underestimate the influence of the opposition to the NLRB should be dispelled by the success with which the policies and actions of the board have been misrepresented. This, I think, is a continuing theme today, some 70-some years later. The first chairman of the NLRB, Warren Madden, was accused of being biased towards unions. And when his first term expired, President Roosevelt decided not to reappoint him to the NLRB because he was very controversial and an election was approaching. Instead, after the 1940 election, President Roosevelt appointed him to the U.S. Court of Claims. While he was confirmed, it was not until after Senator Taft attacked him on the floor of the Senate for 4 hours, saying that he had shown no judicial temperament whatsoever and had perpetrated a gross perversion of justice while chair of the NLRB. The NLRB first general counsel, Charles Fahey, talked about the board's opponents and the hearings that were held in the Congress investigating the NLRB, he said it's a drum fire of attack that they keep up and keep up and keep up. So, in other words, these are just to illustrate that the statute was born out of controversy and is no stranger to it. So let's fast forward to the more recent era. And I believe that the real storm clouds began to gather in September 2007. That was then a President Bush appointed majority board. And in September of 2007, the board issued some 60 divided decisions, divided on party lines, that were dubbed by the labor movement the September Massacre. That led to a congressional hearing at the end of 2007, and then by January 1st, 2008, what we were left with was a two-member board. The chairman's term had expired and two recess appointments, one Democratic, one Republican. Their appointments had expired at the end of December. I think this two-member board, and it was myself and a Republican, Peter Schomburg, I would say that this two-member board was perhaps the most obvious legacy of the Bush era and the controversy within the board itself, the division within the boards, and the controversy surrounding it. This two-member board ended up lasting for 27 months. And that was because, first, the last year of President Bush's administration, the Senate, which was then majority Democratic, decided that it would not go into recess at all for that year so that President Bush could make no recess appointments to the NLRB, to any agency, to any court. My colleague and I decided that to the extent we were able to reach agreement on cases, we would continue to issue decisions. And we did that. Remarkably, we were able, over the course of the 27 months, to issue nearly 600 decisions. I say remarkably because anyone who knows my colleague and me would know that we disagreed on virtually nothing. Nonetheless, we were able to come together. Now, on the theory that no good deed goes unpunished, our authority to issue decisions as a two-member board was challenged in numerous cases. And ultimately, in June 2010, the Supreme Court decided the case called New Process Steel versus NLRB, deciding that two members was not a quorum and that the decisions that were issued were invalid. But a lot happened between the beginning of the two-member board and that Supreme Court decision, aside from the nearly 600 decisions that we issued. Of course, later in 2008, President Obama was elected, to the great hope of organized labor and to the great fears of the business community. Organized labor was hoping for the first reform to the labor law since essentially 1947, putting aside less significant kinds of amendments in between. That was called the Employee Free Choice Act. So keep in mind also that when President Obama took office in early 2009, the country had by then fallen into an economic crisis. The Employee Free Choice Act was introduced into the Congress in March 2009, and I think very presciently, a Washington Post political commentator wrote about what he observed. And I'm going to read you a paragraph because I think it's really quite telling. Remember, this is March 2009, right after President Obama has been elected. He said, "The Employee Free Choice Act seemed destined to be a relatively narrow clash between unions and employers. But amid the economic downturn, it is turning into a debate over fundamental questions of American capitalism. The environment in which the bill is being debated has further ratcheted up the rhetoric, revealing a divide as wide as that on any other major issue on President Obama's agenda. The two sides put forth starkly different versions of both history and present-day reality, making it hard to imagine how the two sides could compromise." And that, I think, as I said, was remarkably prescient. I think in March 2009, most in labor and most in business would have assumed that the Employee Free Choice Act would be enacted. After all, the Democrats had 60 votes, enough for a supermajority. But indeed, a heated skirmish ensued during 2009 with both labor and business investing a lot of money and effort to try to convince the Congress and the public of their positions about it. And the heat and controversy accelerated as the year went on. President Obama also made 3 nominations to fill the 3 vacancies, 2 Democrats and 1 Republican. One of those Democrats, Craig Becker, immediately became controversial, and the struggle over his nomination really was swept into the whole controversy over the Employee Free Choice Act. The Employee Free Choice Act turned out not to be a legislative priority. That, of course, was reserved for health care reform. And as you will recall, the controversy over health care accelerated as that went on, leading to the creation of the Tea Party and delay of labor law reform, delay of confirmation of President Obama's nominees to the NLRB. Also during that time, Senator Kennedy died, and he was eventually replaced by Scott Brown. In early 2010, Scott Brown announced that he was coming to Washington early in order to vote on several things, including a cloture vote to break a filibuster over the nomination of Craig Becker. In fact, there were not sufficient votes to invoke cloture, only 52 votes, and so the nomination of Craig Becker was never brought to an up or down vote. Of course, by this point, November 2010, midterm elections had been held, and the House of Representatives went from majority Democratic to majority Republican. And once the new Congress was seated in early 2011, intense scrutiny of the NLRB began. President Obama, in early 2010, recess appointed Craig Becker and the other Democrat to the NLRB in April of 2010. And under pressure from the Republicans a few months later, there was a vote to confirm the Republican nominee and the one non-controversial Democrat. So in June 2010, we had, for the first time in a long time, 5 members on the board, although not 5 members confirmed. And we then set about to do the things that had been put aside during this 27-month 2-member board, including issuing new decisions on the approximately 120 cases that had been challenged that were issued by the 2-member board. Those were not controversial. Some of the cases that the board began to decide raised a degree of controversy. One of the things that we did in about 10, 12 cases was to seek briefing from the parties on certain issues. We did that for the sake of greater transparency and public input, but at a political cost, because the mere seeking of briefing on some of those cases generated enormous controversy and conflict with the Congress. Now, all of you have probably heard about the one thing that was done that was the most controversial, probably, and that was the issuance by the agency's general counsel of a complaint against the Boeing company in April of 2011. This issuance of a complaint really provoked a firestorm of criticism from many in the Congress, including the whole South Carolina delegation, and from many in the public arena, including many in the business press. I'll come back to that. But basically what the complaint alleged was that Boeing had retaliated against its unionized machinists in the state of Washington because they had struck on repeated occasions during contract negotiations. The CEO of Boeing announced that they were going to build its new Dreamliner in South Carolina, in a new facility in South Carolina, because, according to the CEO, the machinists had struck every 4 years. So this was alleged to be unlawful retaliation against the machinists for exercising their lawful right to strike. Just to finish up a little bit on the chronology, my third term on the NLRB expired in August 2011. When my term expired, it left the board with 3 members, 2 Democrats and 1 Republican. There was immediately a demand that the Republican board member resign so that the board would go down to 2 members. And as was said, if you resign your position, the NLRB will become incapacitated, unable to wreak any more havoc on America's job creators. That was led by Governor of South Carolina, Nikki Haley, and some others. He did not resign, although he did threaten to resign a few months later when the remaining 2 Democratic board members determined to proceed with a rulemaking that would streamline the board's procedures for conducting elections. That became immediately controversial, inflammatory. Ultimately, he did not resign for reasons I don't really need to go into deeply here. But let's just say this period has been one of enormous political upheaval and difficulty. In January 2012, Craig Becker's recess appointment expired. And at that point, the board did risk going down to 2 members. President Obama at that point made 3 recess appointments to the NLRB. Very controversial, and I'll try to run through why quickly. So earlier in 2011, the Republican-led House of Representatives announced that they were not going to permit the Senate to go into recess for the rest of President Obama's first term because they did not want Elizabeth Warren to be recess appointed to head the Consumer Finance Protection Board. Well, you might say, what does the House of Representatives have to do with the confirmation of nominees? Well, many of us learned for the first time that there's a small provision in the Constitution that says that if the Congress is going to recess for more than 3 days, you need the consent of both houses. Probably never invoked, at least for this purpose. So the House of Representatives, majority Republican, announced that it wasn't going to permit the Senate to recess anymore. So come around to January 2012, the board is at risk of going down to 2 members. We know now that the board can't, a 2-member board can't issue decisions. And President Obama, on the advice of the Office of Special Counsel and the Justice Department, recess appointed 3 members to the NLRB so that it would not become dysfunctional, and Richard Cordray to head the Consumer Finance Protection Board so it could function. He didn't recess appoint a whole slew of other nominees that were pending in the Senate, just these, so these 2 agencies could operate. Needless to say, these recess appointments were immediately controversial. And they were challenged in numerous courts. There are legal challenges pending in several circuit courts of appeal. But as I mentioned at the beginning, in January of this year, the DC Circuit issued the first decision in what I would call a breathtaking decision. It is really, in some ways, I think, a tour de force of textual interpretation. And it was a decision that the president's recess appointments were unconstitutional. Now, the president's theory in making the recess appointments was that the Congress, the Senate, was not really in session because someone would come in every few days, gavel in, gavel out, for pro forma sessions. And the theory was the Senate's not really in session, it's really in recess. The case was presented to the DC Circuit on those grounds. Is the president permitted to do that? And as someone might say, does the president have the ability to decide when the Senate is in recess or not? But the court's decision went well beyond that, and in essence would invalidate almost every recess appointment made by presidents, Republican and Democratic, for the last 100 or 150 years or more. What the court decided was that the recess appointment language in the Constitution talks about the president's authority to make recess appointments during the recess of the Congress. And the court said the recess means only the recess that occurs between the sessions of a Congress. Usually there are 2 sessions of a Congress. And cannot be read to mean any recess that occurs during a session of Congress, which is when the vast majority of recess appointments are made. August recess, Christmas recess. None of those would be considered inter-session. They would be intra-session. The court said that's not permitted by the Constitution. And they also said that the appointment had to become vacant during the recess. So if an appointment became vacant in April or May or June, that wouldn't be normally a inter-session recess. The court made clear that just because this was contrary to practice for the last 100, 150 years didn't matter, because it was constitutionally correct, and they went through a large and lengthy textual analysis. Their concern was, they said, that the president shouldn't have the authority to take this authority, shouldn't have the ability to take this power to himself. They talked about a risk of despotism. Of course, the contrary risk is that the government can't function. You combine this decision with the frequent use of the filibuster that we've seen in the last few years, and you begin to wonder, the question I posed, is an agency like the NLRB, which is controversial, is it really politically viable, notwithstanding the broader government itself? So, that's pretty much the chronology of what I call record accumulation of difficulties over the last few years. This was coupled by extraordinarily rancorous and overheated rhetoric about the board, what the board did, and about its members. The rhetoric I noticed was really kind of three categories. One is it invoked the outdated prejudices of another era with frequent cries of Marxist or socialist or Trotskyist. When the General Counsel issued the complaint against the Boeing Corporation, I received something in the mail, an anonymous note that said, "Withdraw the Boeing complaint, you partisan progressive Marxist moron." When I wrote a concurring decision suggesting that one legal framework be changed, there was an editorial that said if Leon Trotsky was around, he'd be happy with today's NLRB. So that kind of rhetoric. Then the rhetoric of personal degradation, calling the board members thugs, stooges, goons. Senator Jim DeMint, formerly senator from South Carolina, now the head of the Heritage Foundation, said that the president has stocked the board with union thugs, and it's pretty amazing in America that we're dealing with this type of third world tyranny. But clearly the most constant and repeated rhetorical refrain was that the government, and particularly the NLRB, was regulating American business to death and was killing jobs. South Carolina Senator Lindsey Graham called the NLRB the grim reaper of job creation. It's been said that Barack Obama's radical appointees on the NLRB continue their jihad against American jobs and the free market economy. And then one of my favorites is on a Fox News show with the news ticker, NLRB fires shot across bow of American free market. The moderator asked the guest, the late Andrew Breitbart, is the NLRB President Obama love affair going to take down the free market project? And Breitbart replied, yes, this is a presidency that's being run by proxy by way of unions, and it's thuggery, it's anti-capitalism. So there's the rhetoric. Then there was what I would call overheated reaction, with more than 24 bills being introduced into the Congress, which were, in my view, intended to distract the board, to discredit the board, to defund the board, and to defang it. There was an amendment offered by a Georgia congressman that would have completely defunded the agency. He said, this New Deal relic is no longer needed. Many of the bills were prompted by the Boeing case itself, many introduced by congressmen and senators from South Carolina. One, Congressman Trey Gowdy introduced a bill to abolish the NLRB entirely, to move its election functions to the Department of Labor, to move its unfair labor practice functions to the Department of Justice. Some of the bills would take away the board's remedial powers, which are already pretty weak. Many of them would undo what the board had done, particularly by way of rulemaking. The board became an issue in the presidential primaries, with several of the candidates, Newt Gingrich, Rick Perry, saying that if they were elected, they would immediately defund and do away with the NLRB. And President Romney ran an ad, Governor Romney ran an ad. Governor Romney ran an ad in January of 2012 where he said that the board, now stacked with union stooges selected by the president, says to a free enterprise like Boeing, you can't build a factory in South Carolina because South Carolina is a right-to-work state. This is simply un-American. It's political payback of the worst kind. It's wrong for America, and it's something that will stop under my administration. Let me just quickly run through the record of what the board was doing during this period, because in my view, the rhetoric, the reaction to what the board was doing was totally disproportionate to what the board did, what it can do, what it might do. As I said, the board reissued these non-controversial two-member board decisions. It entered into deciding some other backed up cases that have been backed up for years involving some novel issues, generated a little bit of controversy. But clearly, aside from the Boeing case, the most controversial thing that the NLRB embarked on were two rulemaking proceedings. One of them would require that employers covered by this statute post a notice in the workplace advising employees what their rights are under the statute. Almost every other workplace statute includes a notice posting requirement. The NLRA does not. We embarked on rulemaking to require this. As one humorist said, you would have thought from the reaction to this that the board was requiring employers to read the Communist Manifesto every day at lunch break. The rulemaking has been challenged along the lines that the board didn't have the authority to do it because it's not in the statute. That case is stuck in the DC Circuit. The board also engaged in a rulemaking to streamline its election procedures. Now, no one can say that the board doesn't have the authority to do rulemaking to change its election procedures. But the rulemaking itself was immensely controversial. It was attacked as essentially trying to enact the Employee Free Choice Act by going around the Congress. Of course, had nothing to do with anything that was in the Employee Free Choice Act. The argument was made that it was attempting to shut employers out of the campaign, that it was going to produce quick snap elections, whatever quick snap elections are, 10 quickie elections where in reality, even under the revised rules, a union election probably could not be held quicker than 20 days after an election petition was filed. I think really what this all was about was the fact that the NLRB has almost never done rulemaking. And so the mere fact that the board was embarking on rulemaking was itself controversial. And then, of course, there was the controversy over the Boeing case, which I've mentioned already. This led to repeated demands for documents from the board, threats of contempt of Congress if the board's general counsel didn't appear at a hearing. Tens of thousands of documents were sought. We battled the Congress over producing documents in a pending case. The president was attacked for, as I mentioned before, that this was political payback. I would, I think, be pretty safe in saying that the president would have been relieved if this complaint had not issued. Far from being political payback, I think it was probably created a political liability for him. And the irony is that the only attempted interference in the Boeing case came not from the White House, but from the Congress itself. So if, as I've suggested, the rhetoric, the fierce reaction had nothing to do with the board's actual record, what did it have to do with? And this is a question I posed at the beginning. So why is the NLRB a lightning rod again at this point? So one argument is the board came back to life. It was like a patient that wiggled its toes in the hospital bed. The critics, I think, were happy to have the NLRB there as long as it was neutered. I'm quoting one of its opponents. but as long as it became active, it was going to be under attack. Senator Lindsey Graham said, when the board faced going down to 2, given its recent activity at the board, inoperable is progress. So inoperable would be fine, but activity wasn't. I would suggest that this was not the most activist board in history, as some have suggested. What it did was not put a dagger to the heart of American capitalism and the free market, but it was active. It believed in enforcing the law meaningfully. So that's one explanation for why the lightning rod. A second one really is that you cannot separate this from the broader political arena, and particularly last year's political election. A couple commentators have said that what we've seen in the last few years in Washington is not kind of an odd blip or politics as usual, but really unprecedented and unbalanced polarization of the parties, particularly the excessive use of the filibuster as a weapon, not of dissent, but of obstruction. Using the filibuster not just so the minority can be heard, but so the majority will can be thwarted. The studies of the filibuster use show that in 2009 and 2010, it was used more than in the 1950s, 60s, and 70s combined. Almost every piece of legislation will be subject to a threatened filibuster. Almost every nomination of any degree of controversy will be subject to a filibuster. Not only was the nomination of Craig Becker threatened with a filibuster, but after the Boeing case issued, certain senators, Lindsey Graham and others, made clear that they would not permit the confirmation of any other nominee of President Obama to the NLRB, which of course is part of the reason why President Obama made the recess appointments. So that's another explanation. Part of a broader assault on the president and his agenda, part of an assault on organized labor, which obviously has been a tremendous support to the Democratic Party, both in terms of money and in terms of rallying voters. But beyond election year politics, I think there has always been and continues to be a very deep divide about the legitimacy of this law and what it represents. I think there are many who have never accepted this law, much as many have never accepted the legitimacy of the New Deal or the administrative state that it ushered in or the vision of national power that the New Deal ushered in. And I think particularly during the recent period with the economic crisis, fueling partisan polarization. I think we're seeing these fault lines really exposed very deeply. So I think what all of this represents is that the NLRB has become a proxy for a broader war against government and particularly regulation of business and the market. Americans seem to be very deeply divided on these issues. There are those who see government as a social good and those who see government as the enemy. These conflicts, I think, entail not simply differences of opinion, but they arise from very asymmetrical moral worldviews or different views of social reality, different views of both the present day and history. We saw this clearly in the divide over the Employee Free Choice Act, those who saw it as a blow to liberty and democracy, and those who saw it as necessary to help restore the purchasing power of workers, which would in turn help restore the nation to economic prosperity. So that's, I think, why a lightning rod, even given the decline of the NLRB, the decline of this law, the decline of organized labor, is that it is emblematic of much broader fault lines in our country. It's emblematic of the nagging and continuing divide over the New Deal, the administrative state, the regulation of business and the market. And it is emblematic of broader values-driven conflicts in our society. Certainly the Occupy and Tea Party movements put these conflicts into high relief. So I want to stop to allow some time for questions, but let me just come back to the second question I posed at the beginning. which is whether this agency remains politically viable given what appears to be a crisis in governance. Certainly in the short run, the NLRB is suffering enormous uncertainty. The Supreme Court is likely to decide the issue of the constitutionality of the recess appointments. The government has announced its intent to seek certiorari. I'm sure that Supreme Court will take it. But assuming it takes it, I think it's unlikely that we'll see a decision before another year. The NLRB has announced that notwithstanding the DC Circuit decision, that it's going to continue to issue decisions. It's been attacked for doing that, for flouting the DC Circuit. Business, the Chamber of Commerce is urging business to seek to appeal all decisions raising these constitutionality of the recess appointment issued. So I think what we are going to see is a period of enormous uncertainty that benefits no one. Doesn't benefit workers, and I don't even think it benefits business. Maybe some businesses think they will benefit from delaying the outcome of union elections or the outcome of unfair labor practice cases, but I would suggest that for most businesses, they want disputes resolved. So the uncertainty really doesn't help anyone. In the longer run, I don't know the answer to the question. I have now really gotten to the point of questioning whether this administrative agency, at the very least, remains politically viable, given the deep divide in our politics and in our society in general. I think that there are enduring values to this law that should be maintained, both for the sake of a fair economy and our democracy, the rule of law, economic advance, the freedom of association, the system of private dispute resolution. These are enduring values, but perhaps they can't be fulfilled in this particular system of governance or legal regime. But I leave that question for all of you to think about, because I want to stop and see if there are any comments or any questions. And again, I thank you for the opportunity to be here and to meet with all of you.
Thank you. We are webcasting, so I'm going to ask anyone, oh, you're going to run around with the, okay. To identify yourself if somebody wants to ask a question, and the microphone will find you.
Nobody.
Everybody is so depressed. Paul.
My name is Paul Gerhardt from the Weatherhead School across the alley here. Back in the 1980s, after the Reagan influence had begun to seep into the picture, there were questions raised about whether the labor movement in general would not be better off if we wouldn't repeal everything right back to the Norris-LaGuardia Act. Do you have any thoughts on that?
Yeah, well, as recently as a couple months ago, I spoke to a group of union representatives in Chicago, and one of them said, this law isn't worth anything to us. It's more like the police. It's not a protection. Just do away with it. I don't know. I think, as I suggested in my final comments, I think there are enduring values in this law that are worth preserving, perhaps like dinosaur DNA. But I'm not sure that the system of governance works anymore. When the appointment process is so broken down, when you can't get some form of labor law reform that would adapt the statute to a very changed workplace and economy, you begin to wonder whether the model really works. I mean, and I don't know what the option is, whether you create a labor tribunal, a labor court of some sort, or whether you put all these disputes into the courts that we have now. But one of my colleagues last fall at the University of Illinois, who gave this lecture a few years ago, we taught together in the fall, and in the first class, he said to students, somewhat provocatively, this is a failed mistake. Excuse me, this is a failed experiment. This is a failed experiment. I don't know if I'm willing to go there yet, because obviously there was a period when it wasn't a failure, when it worked, when lots of people were able to benefit from collective bargaining, to work under collective bargaining agreements, to have a middle-class way of life. But every time I thought that the controversy might kind of diminish, every time I thought there might be a silver lining to the controversy, because at least it was serving the purpose of educating people and enhancing awareness of this law and what it meant, every time I would think that, it would get worse. And certainly the DC Circuit decision, and it's not necessarily the last word, the Supreme Court won't necessarily adopt this decision, but if this decision were to remain the last word, then the decision on recess appointments, plus the filibuster, plus a desire in general to obstruct, I don't know how the governance goes on. And so in that sense, you know, what good does the statute do anyway? So I don't know. I think there's some in labor who would agree with you, though.
So I worked for the EEOC, Equal Employment Opportunity Commission, for a long time, and it seems to have, it has its troubles, but less so than the NLRB, and I'm wondering if you have any thoughts as to why that is. Why wouldn't it be as attacked as the NLRB?
NYU law professor Cynthia Estlin has, I think she's written on it. I've heard her speak on this very issue. And she uses the word that I'm not crazy about, but she says the EEOC and discrimination law is more digestible for people, and more digestible than labor law. One management lawyer sitting in the audience when she gave the speech said, it just doesn't cost business as much as labor law costs. And the quip we always used to use is that business owners at the country club would be ashamed to have to admit that they were accused of race or sex or religious discrimination. But if they defeated a union organizing drive, they brag about it. So I think it goes back to why this law is such a lightning rod, because it really, I mean, it does go to fundamentals of American capitalism. It does go to the ability of business to be able to operate unencumbered, not having to bargain with unions. It goes to what it costs business. Goes to, I think, to issues of equality. It goes to issues of class. Goes to the whole administrative state. I mean, I think this agency is really the quintessential New Deal agency. So I think for all these reasons, the EEOC is just far less incendiary. More accepted, perhaps, at this point, too.
In light of the deep political divide that you've described, if a Republican were to win in 2016 and the Congress remained divided, would you expect any different result in confirmation of nominees? You know,
people will point out that, some people will point out that the Democrats started this. Remember I said the last year President Bush, the Democrats in the Senate refused to recess, and so President Bush couldn't make recess appointments. And then I think that tactic was escalated when it wasn't the Senate that refused to recess last year. It was the House of Representatives that refused to let the Senate recess. So the tactic was escalated a little bit more. At this point, I mean, I read someone recently talking about once you break the taboo, it just continues to escalate. And the only change that I could see really is a change in the filibuster rules, which wasn't done this year. Ironically, this decision issued by the DC Circuit a day after Harry Reid and the Senate Democrats decided not to embark on a significant reform of the filibuster rules. Who knows what they would have done had the decision issued before that. I could foresee with continuing divided government that these tactics are going to continue. I mean, the one glimmer of hope that I have, and maybe I'm a Pollyanna, is that if we are able to see immigration reform as a bipartisan effort particularly with the AFL-CIO and the Chamber of Commerce coming out with a joint statement. And if it actually happens, maybe, just maybe, there'll be a little window of opportunity to thaw some of this divide. Some commentators are saying, well, maybe there's a hint of a thaw here and there. I'm not sure that I see it on any kind of major scale. But I would say that absent a major thaw or absent filibuster reform or something like that, that this crisis is probably going to continue.
The landlord puts us out at this point. So I want to, first of all, let you know that there is a reception. Nancy, I'm not sure. In the rotunda, I'm guessing, but we'll find it. And for my labor law students who are here, notwithstanding everything you've just heard, we will meet tomorrow morning. And please, all of you, join me in thanking Chairman Liebman. Terrific.